Okay, welcome everyone. We'd like to welcome you to this wonderful webinar that's been presented by experts from Finnegan, Elliot Cook and Jeff Berkowitz. I'll let them introduce themselves and the theme of our webinar. We'll just start with a little introduction about AEAI. Our association is basically a hub for engineers and people from technology fields in Israel that are, we have several societies within the association, such as Data Science, which is the society that's showcasing this webinar for you tonight. And I would like to show you a very short video, if you would allow me, that would show a little bit of our activity. Wonderful. Thank you everyone for your patience. Elliot and Jeff, I'll let you take it away.
All right, hi everybody. This is Elliot here from Finnegan. I'm joined by my colleague Jeff Berkowitz. Jeff and I are both in Finnegan's Reston office. We've worked together for many years. We've been to trial together successfully. We've worked on many prosecution matters too. And just to briefly introduce myself, I'm a patent attorney and I do both litigation and also prosecution. So that means litigating patents in court, asserting patents, and also defending clients against patents. And also obtaining patents from the patent office. And sometimes that also involves challenging patents at the patent office too. So really, the full gamut of patent assertion and patent defense, and also patent procurement. Jeff?
Thank you, Elliot. Good afternoon, everyone. So my name is Jeff Berkowitz. I've been with Finnegan for over 30 years now. I'm a little bit of a dinosaur working in one place for as long as I have, but I think when you find some place that works for you, you stick with it, in my opinion. And I've been doing patents in the computer field for all that time. It was relatively new to see patents focused in the computer science field when I got started, but that's been my focus ever since, including, as Elliot outlined, both helping companies to develop patent portfolios, as well as to litigate patents in federal courts here in the United States, all over the country. We're based, as Elliot said, in Virginia. Our firm is the largest office we have is based in Washington, D.C., just 10 or so miles away from where we are here in Virginia. But Virginia is also a place where the court that handles patent matters is well known for doing these kinds of cases very quickly. And so the quicker the cases, if you will, the more challenging they can be. At the same time, we've helped companies to develop strong portfolios now in Israel, well over 150 or so clients that we have in Israel that we've helped with, also with helping them to develop portfolios as well as to litigate patents here in the United States. Oh, one other thing, at the back of the presentation, you'll see that our contact information is there as well. You can go to our firm's website, Fennigan.com, and you can find additional information related to the firm as well as to both myself and Elliot as well. So we're going to get started with posing a question apropos for the group, we think, on why do cybersecurity patents matter? What's important here really is, and I think a framework like this is always helpful in terms of these presentations, is what really matters right now is to understand what we mean by why a patent matters, in this case, focusing on cybersecurity for our attendees. Patents matter because they can add value to companies. They can help companies. And what do we mean by adding value? They can help companies to block competition in a competitive area. They can add value to the company for investors. Oftentimes, it's pretty typical for investors to look at companies, typically younger companies, but even older companies, well-established companies, looking at their portfolios and reflecting on how those portfolios add value to the company in a variety of different ways. One of which is if it's a competitive area that the company is operating in, to see how much the competition is perhaps using the technology, the patented technology of the company. And another area that patents, of course, can be very helpful with is in generating revenue potentially for companies. Companies can use patents to help to generate revenue through licensing systems. If you could go to the next slide. What we thought we would do is, by way of background, is talk about a recent case, by way of example rather, which involved Cisco. Cisco was recently sued a couple of years ago, actually now, by Centripetal Networks, and the case was tried very recently, and again in a Virginia court here that where the case went to trial in front of a judge very quickly, and Cisco was ordered by the judge to pay in excess of $1.9 billion. All of the patents related to security features and a variety of different products. You can go to the next slide. So what we're going to do is give you a little bit of background about how this little known company, which is also a company that's a small company based here in Virginia, was able to use its patents in this field against an industry giant like Cisco and obtain such an enormous, really, award of damages against Cisco. If you can go to the next slide. So how did they do this? So it's a small company, new company. It was founded just over 10 years ago, 12 years ago, February of 2009. It took a number of years for them to get some initial funding. And as soon as they got that initial funding, around the same time, they started filing for patents. They filed a number of different patents during that time. Roughly about 2012, excuse me, to 2014 is when they filed the patents that were asserted against Cisco in this case. And as you can see from this timeline, it didn't go very far. 9 years from the founding of the company, they were in a position, they felt, to sue Cisco. And so they sued Cisco in February of 2018. Just 3 years ago, the case went to trial in under 2 years, even with delays due to COVID. It still went to trial very, very quickly. Most cases in Virginia go to trial between 9 and 12 months in a non-pandemic time frame, at least. And then the judge held a trial in the fall of 2020 and ultimately issued his decision with really what is an enormous victory for Centripetal. Now, I'm sure when you look up, you'll see Centripetal and Cisco continue to battle over this award, but nevertheless, Centripetal is certainly in the driver's seat, so to speak, having achieved this victory against Cisco. Go to the next slide.
So one of the most notable things about the strategy that Centripetal had in acquiring patents and asserting patents is they didn't just have one patent, and this is something we'll talk about. They didn't fall into the trap that a lot of companies fall into of saying, I have this invention, and I'm going to get a single patent to cover this invention, and then I'm done. I've patented my invention, I've protected my company, mission accomplished, that's all I need to do. That's a very incomplete way to think about protecting your company and boosting the value of your company, as Jeff was mentioning. Centripetal did not take that approach. They took a much more strategic approach. They had many patents and they asserted 11 in this case. Why did they assert 11? Why not just one patent? Well, what happened was Cisco challenged all of the patents at the patent office, and Cisco was pretty successful. They were successful in invalidating all the claims out of 6 of these patents. So what happened at the trial time, Centripetal just had 5 patents left to assert that were not found invalid already at the patent office. So it took those 5 patents and it asserted 2 claims per patent. And that's really what they had left. If they only had 1 patent at the beginning, they may not have had any claims to assert. So it was very good from Centripetal's perspective to think about, here's my invention and here are the different ways I can claim it in different patents. And that's what they did. And this is a brief summary of the technology. And as Jeff mentioned, it's really just different techniques to protect a corporate network against cyber attacks. That's what all the different patents relate to. And another very important thing that led Centripetal to this $1.9 billion damages award was that it targeted its patents at key Cisco technologies. We're not talking about the bells and the whistles, the minor features, the trivial features that Cisco could easily design around with a minor change to its software. Instead, Centripetal directed its patents to key features of Cisco switches, routers, firewalls. And that's what led to the ultimate damages number that we see. It was a matter of Centripetal lining its patents up to target these key Cisco technologies that Cisco really was generating a lot of money from. Not the optional features, but really the core features of Cisco's products. And this is the computation that leads us to the $1.9 billion figure. A lot of it was past damages, $755 million, using a 10% royalty rate. What's also notable about this case is that there was enhancement of damages. Enhancement can occur when there's willful infringement. And willful infringement in a nutshell means that Cisco did not have reasonable or meritorious defenses on either infringement or validity for these patents. What it comes down to is that Centripetal's positions were very strong and Cisco's were very weak. And so what the court did is it applied a 2.5x multiplier to the damages award, a very significant multiplier in this case. In addition, there was a $27 million in prejudgment interest, something that is often overlooked in patent cases, but we always recommend focusing in on. It can be a very substantial source of damages as well in patent cases, especially when the infringement's been going on for many years. And that takes us to the grand total of $1.9 billion. And of course, that's not even the total amount. There's also an ongoing royalty that Cisco will need to pay based on future infringement. Its products, its routers, its switches are still subject to infringement of these patents going out into the future. And the real number is going to be growing substantially beyond $1.9 billion.
But not all patents turn out to be as valuable as Centripetal's patents in this particular case. We're going to start here with a little bit of an assumption that all of your inventions actually start out as diamonds as opposed to coal. And we're really focusing this presentation from here on what you can do to prevent those diamonds, if you will, from turning into coal. That is, the things that you have control over, as opposed to, and you can do what you can do various different things to not just maintain value, but to potentially even increase the value of your inventions through patenting them. And we're going to go through a number of different problems that come up, as well as a variety of different tips and strategies for addressing those kinds of problems. Go to the next slide.
And so we'll talk about the top 4. The first is patent profanity, a term that I'm pretty sure Finnegan has coined over the years. It's a funny term, and it's a very important term too, as Jeff will talk about. Patent abstractness, that's something that can lead to a patent not being granted or found invalid because of abstractness. Indefiniteness, just being unclear in the claims, unclear as to what you're claiming as your invention. And maybe the most important, strategic focus. A lot of companies just lack the critical strategic focus that really Centripetal showed us in their patent portfolio.
So these really are the top 4 that we see, both in assisting companies and developing portfolios. It's not unusual for us to be brought in after some patents have already been applied for, and we are asked to look at those patents applications at that point and assess any issues and concerns that may be there. And so it's not unusual for us to encounter these kinds of issues and obviously do our best to try and address them. These are also very, very frequently. In fact, I think certainly the top three, patent profanity, abstractness, and indefiniteness, are among really the top defenses that come up in patent litigation these days. So we're going to start with this patent profanity, and as Elliot pointed out, it's really a term that I think you can track back to one of our partners, Tom Irving. Really, if you will, he invented this particular term. And what we're talking about in terms of patent profanity in general is where these are things that inventors do in their drafting of applications, as well as in arguing or what we call prosecuting applications before the patent office, that tend to affect the scope of the claims, make the claims narrower, for example, and therefore affect the value of the claim, right? If a claim, typically, if a claim is narrower, it covers less ground. And if it covers less ground, then it has less value. There are certainly situations where a claim may cover less ground in my example there, but nevertheless still can be valuable in that it avoids certain prior art at the same time. And we'll talk a little bit about that as well. So I want to talk about, first, there are roughly three categories of what we call patent profanity. The first category is where patent applications include descriptions of importance, or what we're referring to as absolutes. So for example, in a patent claim, for example, or in the specification rather, in the first instance, it says that something is critical to the invention, or it's necessary in order to solve the problem that the invention was directed to. It is necessary to configure the invention in a particular way. And this is something that comes up almost always in patents, I would say, that were drafted before 2004, 2005, because I think that's where drafters started to learn about being more careful. But it still happens in more recently drafted applications. I'm working on a case right now where I'm looking at applications that were filed in 2012, and we're dealing with, in that case, it's actually the claim in the specification uses the word every. Okay, so for example, it may say in the claim that in each and every instance, this particular process works this way. Okay, that means that it can't work any other way in some other instances. And so these are examples of where something is described in the application as critical, important, or necessary to carrying out the invention, as well as where the description is also in the specification talks about how in every instance, a particular process has to work, for example, in a specific way, and it can't work any other way. You can go to the next slide. So another example of patent profanity in another category here is where the application lacks what I'm going to call as what I'm going to describe now as generality. Okay, instead of saying in the specification, an implementation of my invention is X, or for example, my invention may be implemented in a certain way, the application actually says my invention is. My invention is not something. Okay, these are instances where in courts, the accused infringer that you're suing for infringement looks at those statements and says, aha, I'm not infringing this patent because this patent says that the invention is defined in a very specific way, And my product actually doesn't have that particular characteristic of the invention in the application. Other ways in which people do this, the same kind of characterization of the invention is through the negative. For example, the prior art includes a particular feature. Let's say the prior art is green and my invention is red, in which case there can be no way or no implementation where you can sue somebody for a green invention. That's very obviously an oversimplification. But those are instances where characterizations of the invention in an application can result in a narrower scope of the claim. And if there's a narrower scope of the claim, then potentially the accused infringer can avoid infringement because of that narrower scope of the claim. Can you go to the next slide? So a third category for patent profanity is where the application, the inventor, either in the application or during comments and discussions with the patent office to get the patent allowed in the first instance, makes certain statements that undermine what we're referring to as patent eligibility. Elliot will go into this a little bit more just after this slide, actually. But patent eligibility is a bigger topic in itself. But what ends up happening, there are two ways in which you can address you can address patentability in the first instance. One is, if you say in your application, for example, this invention automates formerly manual processes, the accused infringer is going to say, aha, this invention is no more than an automation of a manual process. Okay, that's one of the ways in which courts have been finding patents invalid for lack of eligibility, where the application or the invention rather is no more than automating a manual process. Another way in which courts are addressing the same issue on eligibility is by looking and seeing whether or not the application says that the invention uses well-known and conventional technology. This is sort of like, if there's one thing you can take away from this discussion today, do not use the words, my invention uses well-known and conventional technology, okay? Your invention does not use well-known and conventional technology. If it does, then it will most certainly be held to not be an invention, if you will. Can you go to the next slide? So these are different ways in which you can avoid patent profanity in your applications and in prosecuting applications in front of the patent office. What you can do is describe examples of the invention. Like I said before, instead of saying my invention is, you can say in some embodiments, my invention includes, or in some embodiments or examples, my invention may, right? It's not an absolute. It's a if you will, optional. There are certain things that may be required, okay, and you can still use the word may even if something is required. There's nothing that says that would be wrong, if you will. Include lots of different embodiments and configurations if you can. This is where you have to be creative in drafting applications. You can't just sit there and say, aha, Shlomo has this idea, let's write this application on his idea. You have to start to think about, okay, well, how many optional ways, if you will, can that idea be implemented? He may have a particular way in which he wanted his invention to be implemented, and that's great. You're going to include that in your application, but you need to include the other options. That goes hand in hand with being forward-looking. That's the idea of, don't simply use the one example. Think about how others may implement the invention in the future, and be very, very careful when negotiating with the patent office to get your patent allowed, which is what it is, right? This is all about, as the image here shows, avoiding potholes, right? You want to make sure that you've got a smooth process to get your patent allowed and avoid these profanities. And so when you're arguing, which is what it is, or negotiating with the patent office to get your patent allowed, you really need to avoid these various different characterizations where you might say in arguing with an examiner, but wait a second, my invention is this, right? You want to avoid those kinds of things. So just like you want to avoid it in your application in the first instance, you want to also avoid those things in arguments with the patent office during the examination.
So would you agree, Jeff, that maybe a good academic paper is very different from a good patent application? You know, maybe in an academic paper, you want to define your invention and get really specific and limiting, but maybe not in a patent application?
Exactly. That's what we often see is these technical descriptions of inventions are really good as technical descriptions of inventions, but that's not the same as a patent. A patent is a legal document, and you have to follow the rules, if you will, for patents, for the patents to ultimately be as valuable as they can be. Not all patents are going to be as valuable, for sure, as centripetals. That was, really good and forward thinking. And as Elliot pointed out, not everything survived, even in that case. But they used a strategy that wasn't limiting really to here's just a technical, here's a white paper of how we're going to get started with our business.
Great. And so next is the topic of what not to do of abstractness. And Jeff was touching on this a little bit. In the next couple of slides, we're going to talk about what this means, but the main takeaway is that you can't claim a mere idea. A patent can't be directed to a mere abstract idea and nothing more. A patent needs to be more concrete. It needs to be more specific and limited to the real world. So it's critical to have an idea and to have a concept. After all, this is intellectual property, but you can't patent a mere idea. And the portion of the United States Patent Code that tells us this in a somewhat abstract way is this portion here, section 101. It says you can patent something that's new and useful, right? So anyone who invents or discovers any new and useful process, machine, manufacture, or composition of matter, etc., may get a patent. And the way that this has been interpreted over time is that if it's not new or it's not useful, you can't get a patent. And that's further been interpreted to mean if something is abstract, you cannot get a patent for it. So in the software world, for example, if you're claiming a mathematical concept, or maybe it's a chemical formula, or maybe it's a business type invention, maybe it's a method of organizing, your stock trading, strategies. A lot of those things are not going to be patentable. A lot of those things are going to be directed to abstract ideas. What's happened over time is that there's been an unwritten rule, so to speak, that if your invention is purely financial in nature, it's really talking about the movement of money, a tax strategy, or trading securities. A lot of those things are going to get a lot of scrutiny. And no matter how you claim those things, it's going to be tough to get them out of the patent office. Not impossible, but if it's financial in nature, it's going to be tough to get it out of the patent office. And if you do, it's going to be tough to enforce it in court. But the good news is that for a lot of other inventions, including fintech innovations that have some technology built into them, but also pretty much every other software type invention, as long as it's new, there's a way to claim it to make it patentable. Avoid mathematical concepts as just the claim itself. The claim can certainly have a mathematical concept underlying it or being a part of it, but don't limit your claim to just the mathematical concept. Don't limit it to just a method of organizing human activity, and just don't claim a mere mental process. A lot of it is, even if your invention is software in nature or has a financial component to it, there's a way to claim it to make it specific and make it technical so that it can be patentable and it can stand up in court. So what happens when we see a claim that's abstract? A claim can be found invalid when it uses generic claim language, like component, right? First component, second component, or unit, right? When it's really covering everything, where there's a generic computing device and there's not a lot of functionality described beyond that. It's just transmitting data to and from, storing data, organizing data. If there's no technological improvement that's being identified, the claim is at risk of being found abstract and therefore invalid. There needs to be a technological improvement, some technological feature that's really making the invention cross the finish line. So another thing to avoid is a situation where your invention is merely computerizing something that has been done before through pen and paper techniques. If your invention is claiming what's been done before manually, if you can find an equivalent in a textbook or some other material that involves somebody doing your invention just manually instead of automatically, your invention is also at risk of being found abstract and therefore not patentable. And another area that the courts have focused on is your claim may be found abstract when it claims the what. It just claims the result of your invention. My invention produces this, right? But it's kind of claimed as a black box. What the courts often want to see, in the patent office too, is the how. How is your invention achieving that result? Don't just claim the what, but also claim at least some of the how to show that your invention is claiming the technological improvement that gets you to the result. And so how to do this? So Jeff was talking in terms of prosecution about how to avoid things like, my invention uses generic components, well-known and conventional components. Don't do that. Make sure that you have a little more specificity, at least in some examples in your specification, so that it's not merely describing black boxes communicating with each other. But another thing that's really important is early on, even before you start to write the application, talk with the inventors about the technological improvements and really seize on these technological improvements and make sure that you include them in the specification, because without them, the invention is at risk of being found abstract, too general, too high level. You want to identify what the specific technological benefits are. Maybe it's increased efficiency, security, speed, maybe it's bandwidth, maybe it's scalability. It could be a lot of different things that are technical, but you need to make sure that you tie your invention to those things. And also balance the breadth of your claims with specific structure and components. There's always a balance between breadth and narrowness in patent claims. You want your claims to be as broad as possible so that everybody in the world infringes them. But if they're too broad, they could be invalid based on prior art. Somebody's done this before, your invention's not new. But also if they're too broad, they could be found abstract. So what we recommend is that you're a little less like Picasso. You're not purely abstract in your invention, the way you describe it and the way that you claim it. Be more like MC Escher. Have an idea, right? Have an idea that you think is new and interesting and inventive, but don't claim it in a purely abstract way. Try to bring a little real world nature to it and talk about the specific technological benefits of your invention.
Elliot, would you see this this notion of abstractness more in software and cybersecurity kind of applications than in other areas?
You do, yeah. There's certainly a risk for software and cybersecurity applications that you'll get these kind of rejections, but primarily it's a claim drafting and application drafting matter where you can avoid these kind of rejections if you draft your application appropriately and you draft your claims appropriately. I deal with many applications in the cybersecurity field, and when we write them appropriately, we get them to the right art units at the patent office. And for the most part, we avoid these type of, they're called 101 rejections, abstractness rejections. So it's a matter of, again, seizing on the technological benefits and building those into the application and into the claims.
So we're going to now turn to our third topic, which is indefiniteness. And indefiniteness, broadly speaking, is where a term in a patent claim is vague or poorly defined. As you can see in this image here that we chose to introduce this, what do you do, right? Can you go in or can't you go in, right? It's as vague perhaps as anything can get. But we're also talking about things that are extremely poorly defined, which of course this sign is also an example of. If we go to the next slide. So consider, for example, this claim on a method for disarming malicious code. We're talking about cybersecurity a little bit here, and so we wanted to give an example that dealt with cybersecurity. So this is a high-level claim. I don't pretend to suggest that it's not something that's been done before. In other words, there's probably prior art out there. This does not come from any particular patent. I made it up. And I also made something else up. So as you can see, it says disarming malicious code, comprising receiving the code, determining that the code is eglaphly likely to include any malicious code, and then altering the code. And as we just highlighted, you can see the word eglaphly is added there. Well, eglaphly is a word, if you will, that has no meaning. It's just a word that's been introduced into the English language that can be used in place of any word. So if it has no meaning, how do you know what it means to be eglaphly likely to include any malicious code? You don't, right? Because it's not a word that means anything. Now, we're going to talk about some concrete examples of where people make this mistake, and where courts have found, rather, that people have made this mistake. If you can go to the next slide. So here are some examples of terms that courts have found to have no particular meaning, or to be indefinite for vagueness, or lack of definition. The first example is just there's no meaning of a term in the field. When an application is drafted, there's no meaning. The application uses a term. In this case, it's magnetic fuzz. And it's a term that has no meaning in the field. But more importantly to that, in that particular instance, the applicant, the inventor, in filing the application, didn't define the term either. So it's not just a term that has no meaning in the field, but it also was a term that wasn't defined. If it was defined, then at least arguably the patent owner in that instance could rely on such a definition. Terms in the specification that are not specifically described. This is another instance where courts, while courts tend to look at claims and claim terms, even something like transactional operator like this, and try to determine what they mean so as to uphold the validity of the claim, oftentimes the claim term itself may have no particular meaning in the field. And when it doesn't, if there's no description of what it is in the specification, then it could be anything. And this is really an instance where it could be anything. What's a transactional operator? It can really be anything. And because it could be anything, just using that term in the specification alone really doesn't help to understand what the scope of the claim is when it says having a transactional operator. So you have to have examples, and we'll go through that in a moment. Terms that are in claims that have no antecedent basis. Now, this is maybe a little bit technical with patents that maybe not everybody on this call is familiar with, but when you're drafting applications, you have to follow a specific set of rules, like I said before, right? And this is really one of those instances where somebody failed to follow the rule, if you will, when drafting the application, or rather drafting the claims. And so by failing to follow that particular rule that we call the antecedent basis rule, in this particular instance, there was a lack of an antecedent basis, so a claim was invalid. This next one is really, really interesting, and it comes up, I'd say relatively rarely, but when it does come up, it's probably the most interesting in my opinion. This is when the terms use when the claim term is something that is subjective. And what I mean by that, and what the courts have said about this, is when the meaning of the term to somebody skilled in the art may be different to different people. In other words, one person may see that particular word to mean one thing, and another person may see that word to mean another thing, right? Minimal redundancy. What is the scope of minimal redundancy? And that may be determined by the reader, as opposed to it being, if you will, objective, right? Aesthetically pleasing is perhaps the best example from this data mines case. But whether or not something is aesthetically pleasing, that is pleasing to somebody's eye, for example, right, is really determined by the person, right? Do I like this picture of the guy scratching his head? Well, maybe I do like that picture, or maybe you don't like that picture, for example, right? So that's really, is it aesthetically pleasing, right? And there's this other instance where terms lack boundaries, right? There's a lack of an explanation of a boundary. In this case, we use the word block-like. How do you know whether or not something it falls within the category of being a block-like, if you will, as opposed to not being block-like, right? What shape does it have to be in order to look like a block? If you can go to the next slide. So here's a block, right? I mean, that's block-like for sure, but if you change the orientation of that, how do you know whether or not it is or isn't block-like? So we want to just very quickly go over a couple of different ways in which you can avoid these problems during claim drafting and during drafting of your application. You can clearly define all terms in the patent specification, right? So this goes to, you don't want to have situations where the application lacks any kind of meaning. Like if you're going to use a term that lacks a particular meaning in a field, then what you want to do is you want to define that particular term. Like we use the example magnetic fuzz, then define magnetic fuzz. Include examples of ranges or boundaries. I have to tell you, I'm working on a case right now where the other side is arguing that the claim actually lacks a description of what the range is. The claim says, within a particular range, right? But they're saying that the range is not defined in the claims. However, in that particular instance, luckily the drafter actually did include a description of the range itself in the specification. So we do have examples of ranges in that particular case. But it's not unusual to see somebody say that, well, this just has to fall within a range of the likelihood of it being malicious code, right? So maybe there's some threshold as to whether or not something is or isn't malicious code, but you don't give an example of what that threshold is, right? And you can be sure that somebody is going to argue that without explaining an example of the threshold, then they're going to say that the claim is indefinite because it doesn't give you that threshold. Sometimes and I already mentioned the subjective language, avoid things like aesthetic pleasing. The bottom line to all of this is be very careful when drafting claims, as well as amending claims during prosecution, during examination. You really need to be careful to avoid these kinds of indefiniteness potholes, to go back to one of our previous images, if you will. Indefiniteness is a matter of where an application really lacks precision. And it's really important to make sure that not just the claims have the precision, but your application has the precision as well.
And so the final topic that we have, and maybe this should be a football image rather than a basketball image, just having had the Super Bowl yesterday here in the US, is a lack of strategic focus. Shaquille O'Neal shooting a foul shot with a blindfold on is not a great idea. He can't make them with no blindfold on. But what we'd like to talk about is the analogy of a company pursuing a patent absent a strategy. And it sounds like something that nobody would ever do, but it's amazing how often it does happen in the real world in practice. And this is how it happens. This is the most common approach that Jeff and I see of companies obtaining patents. It's a technology first approach. It's the cart before the horse. And this is how it works. It happens this way all the time. The inventor has an idea. The inventor tells the patent attorney the idea, and then the patent attorney acts as a scribe and just writes down the invention, writes up the application, and last but not least, sticks some claims at the end. The claims are coming last. This is a technology first approach flowing from the inventor to the patent attorney, and the specification is just a technical description of what the invention is. This is really the opposite of what should happen. As we'll talk about, you should talk first about the business. Talk with the company executives, the marketing folks, about what the market looks like. Where's the business going to go in the future? What lines of revenue do we want to protect? What's important to the business and what's not? Not every innovation is important to a company. Some are, some are not. the claims need to come first as a result of this process. So we need to think about where's the company going? What does the business look like? What's the business strategy? And then we need to think about how to claim innovations that further that business strategy. It needs to be a claims first process, not a technology first process. And once you have the claims, then you can begin to write the specification. That comes next. First, you need to know the business. Then you craft claims to cover innovations to drive the business forward. And then you write the patent specification to support the claims. That's the process. It's often not what companies do. This is the most common approach. This is what we see all the time. So what happens a lot of the time is, companies just check the patent box. They give it the Czech Republic on the box. We apologize. Corny humor. But this is what often happens too. Investors want to see patents. So the company just checks the box. They say, yep, we have a patent. We filed a provisional application. I'm not sure what happened to it, but we did. We filed something, right? And that's it. That's not a way to obtain value at all through patents. Another approach is, we need to recognize the inventor. This inventor's, been putting in long hours. The software is really successful. Let's allow them to get a patent, right? Again, not a good way to generate value. Other companies have patents. Why don't we, right? This is a way to think about maybe getting numbers of patents or just having patents for the purpose of showing the competition that you have them, but not necessarily a way to align patents with the company's business. That's when you get patent value. And just putting patents on the wall, obviously, is not a way to obtain value either through patents. These don't obtain value through patents because patent strategy needs to occur really at all phases, right? So the way to obtain value through patents is to think about, again, where the business is going, what are the key lines of revenue that you need to protect, not only now, but into the future. Is the company going to expand in the future? Is this one technology going to be used in combination with another technology? One example that we talk about very often is the Nest thermostat, a smart AI-based thermostat that was developed over time to incorporate things like advertising and social media features. That's very forward-looking, and that's a great way to obtain value through patents, to think about how the technology can be applied into the future. And so the things to do are these. Understand the business strategy first at the outset, before you start claiming things and before you start writing applications. Understand the business, ask the inventors questions about their invention. A lot of the time, the inventors have a very specific idea of how the invention can be applied. And of course they do. It's their job to think about developing software or developing a product. And they have a very specific idea about how their invention can be applied. You need to ask them the question, though, how else can the invention be applied? And a lot of the time, the result of that is a very valuable process of thinking about different applications of the invention, different embodiments, different ways to claim the invention. And as you can see through Centripetal's 11 patents that they asserted, that can be very, very valuable. Think about the future. Don't just think about how the product exists now. You don't need to build the product before you write the patent application. As long as you have the idea of the invention, you can write the patent application. So you should patent now what you think the technology is going to look like in the future. Don't limit yourself to just the world as it is now. And again, it needs to be a claims first process. Many law firms and many companies do not do it this way. They take the technology first approach and end up with very limited, very frozen in time type patents. That's not a very good approach. And to Jeff's point earlier about not losing focus during prosecution with claim amendments and introducing indefinite terms, also don't lose focus during prosecution in view of your strategic goals. Your strategic goals are, those things that are driving the patent in the first place. So during prosecution, don't take a valuable claim and make it a less valuable claim by limiting it in certain ways or changing its focus. Make sure that you continue on the path that you set out initially of making your claims valuable.
There's one other point I just wanted to add to this, Elliot, in that we appreciate that, so I think the most important, another important rather thing from my standpoint here is that this is something that requires forward thinking. And forward thinking really is something that is going to require typically more of an investment up front in terms of obtaining patents that avoid these kinds of pitfalls. That is, it doesn't necessarily need to, if you will, break the bank to do this, right? But it does require advanced thinking. And advanced thinking means you got to put that effort in ahead of time and not look back and say, I should have done it differently, right? Or I could have done it differently if only I had done it differently. And what we often see is, as I said at the outset, we're often brought in to look at to help out companies after they've already filed applications. And sometimes after they've already done that, it's really hard to help them with that particular application that is making it better, stronger, ultimately. Not that long ago, helped out a company that they filed an application and it had some very narrow claims that it actually got issued, but it had some very narrow claims that nobody could infringe, essentially. We looked at it, studied it. Nobody could infringe these claims based on our analysis. And even if possibly that it could read on something, somebody, a competitor in the field, it could easily be designed around. And so what we did was, there's a tool that's available. We filed what's called a reissue application to try and fix those claims. That is, address the claims, make them broader. And we were successful because we got involved in time to be successful in that particular instance. But that was an instance where at least the specification that we were dealing with helped us. In other words, it didn't have some of these problems and concerns that we've talked about today. So that's one other thing on being strategic in your focus that I just wanted to add. Thank you.
Great. Excellent. And I think we've saved a few minutes, Jeff, for questions here.
Yeah, I would like to give you a question from Avi Shaked from our audience. He's asking, can the how of the invention be used to distinguish a patent from prior art? If so, can you give some tips how this can be approached?
Sure. Jeff, you want to take that?
No, go ahead, please.
Okay. Well, the answer is yes. It can and it should, right? So as we talked about, the how should be part of the claim. You shouldn't only claim the result of a process, a network that is secure. You should claim how you're making the network secure, what specific steps you're taking to achieve security, what data you're analyzing, what type of algorithm you're using. Tips in terms of how this can be approached. I think what I would suggest is it's a continuum between being really specific on one end and being really broad on the other ends. You want to be specific enough about the how to show the examiner that you're claiming the solution to the problem, not just the result of solving the problem. So if it's an algorithm, if you have a software algorithm for achieving network security, think about how you can take the very specific steps that you have in your source code, for example, and you can claim those at a slightly higher level of generality. You're taking steps 1 through 12, but maybe there's a way to claim those as steps 1 through 5, or maybe it's 1 through 3. If you can take those really specific steps that you have, your how, and you can claim those as slightly more broad, but not too broad, not abstract, slightly more broad steps, that's how you'd want to write your patent claim. And it's a technology by technology question, but that's how you approach it.
Yeah, I have another example there to just bring that home, which is, let's say your claim is to optimize security, right? And I have this system that's going to optimize security on a platform or something like that. It's not unusual for somebody to say, well, I'm going to optimize security without actually saying how they're going to do it. It's critical that the description of how that optimization is achieved is described. Now, oftentimes examiners, if you just said in a claim, well, I'm going to optimize security or something like that, they're going to say, well, you need to be more specific in the claim as to how you're going to do that, right? And if you don't have the details in the specification as to how you're going to do that, it's going to be impossible really to respond and address the examiner's concerns there. Now, this doesn't mean that when you respond, you're suddenly going to be, falling into one of these traps like patent profanity, like we just talked about, right? It's absolutely possible to respond to an examiner's rejection on something like that you need to be more specific, while at the same time achieving the maximum scope that you can for that particular claim.
Wonderful. Let's see if we have any more questions. Just a moment. All right, there are just a few thank yous from the attendees. All right. Well, let me just say thank you very much, first of all, Elliot and Jeff. It was a brilliant presentation. If anybody has any more questions, you're welcome to chat with us directly. You can answer in the survey that we will be sending you. There's a place to sign in your questions, and we'll be happy to refer them to Elliot and Jeff for further review, and they will be answering you directly. I'm just going to say the same thing in Hebrew as well. תודה לכל מי שהשתתף, אתם בהחלט מוזמנים להגיב. גם כרגע, ונספיק לענות נשמח, ובמידה ולא, אנחנו נשלח לכם גם סקר קצר על איך היה הוובינר, ושם יש מקום בעצם להערות שלכם ולשאלות פתוחות שתרצו שנשאל אותם ישירות בשמחה. Okay, let's see. Okay, well, there's just a few thank yous from everybody. Wonderful. So thank you very much again, Elliot and Jeff. It was a pleasure having you. תודה לכל המשתתפים. We will be sharing the video in a couple of days, and you'll be able to see it on our website, on our YouTube page, and we'll be sending it also the email link directly to all of you.
Well, thank you all as well for participating today.
Thank you very much.